Good morning, this is your Kelso Report for Friday, October 21st, and I'm your host, Clark Kelso. Well, it was a pretty light day for the courts yesterday. We have just one-liner in State Compensation Insurance Fund versus Wall Design Incorporated. The 4th District held that where an insurance policy states that the insurer has 3 years after the end of the policy period to complete an audit of the insured's records in order to determine the final premium due, and the insurer completes that audit within the 3-year period and then timely submits a final bill to the insured, the statute of limitations begins to run on the date the final bill is sent. This holding follows the general rule that the statute of limitations for an executory contract does not begin to run until the time for full performance has arrived. In the case of the insurance contract, that time for full performance did not arise until after the audit was complete and a final bill had been submitted. Under this interpretation, the insurance company's action for breach of contract for non-payment was timely, even though the non-payment had occurred a long time ago. But they completed their audit, and then they submitted their final bill. That's when the limitations period began. Well, we did have 3 interesting grants of review by the California Supreme Court. First, the California Supreme Court granted review in People v. Buzza, which involves search and seizure in the modern age of DNA samples and databases. The Forensic Data Identification Database and Data Bank Act of 1998 requires that a DNA sample be taken from all adults arrested for or charged with any felony offense immediately following arrest or during the booking process or as soon as administratively practicable after arrest. The 1st District Court of Appeal held earlier this year that the statute violated the 4th Amendment because it authorized taking of the DNA at a time when the defendant was entitled, or the arrestee, was entitled to the presumption of innocence, and there had been no judicial determination of probable cause to believe that the person had committed the offense for which he was arrested. My commentary on this case on August 5th included the following conclusion, quote, "Because of the importance of the issue, the breadth of the court's holding is applied to standard police practices, and the really exhaustive opinion written by Judge Klein of the 1st District, I think there's a good chance the California Supreme Court will grant review to consider the questions presented." Close quote. Well, that good chance has now turned into a reality. The second case where they granted review is an evidence case involving DUI breath analyzers. In People v. Van Gelder, the Court of Appeal had held that the court should have admitted expert testimony in a DUI prosecution that challenged the reliability of the common devices used by police to test blood alcohol levels using a breath test. The testimony was to the effect that a breath test does not reliably test the grams of alcohol in the breath because of individual physiological differences in how alcohol level in the breath is transmitted from deep within the lungs to the mouth and to the test device. If this testimony is reproducible in subsequent cases, it will be particularly important where the breath test results are close to the .08 limit, since, as the Court of Appeal noted, even a small error in measuring the blood alcohol level could possibly turn a marginally legal reading into an illegal reading. Well, when I commented on this case back on July 5th, I said that, quote, "Given the prevalence and importance of the issue, it would not surprise me to see the California Supreme Court take up the case," close quote. So I'm 2 for 2 this morning. Let's see if I can keep this going. Last case deals with public financing. The court granted review in Concerned Citizens for Responsible Government versus West Point Fire Protection District, where the 3rd District struck down a special assessment imposed on parcels within the West Point Fire Protection District and approved by 62% of the relevant voters because it was clear the assessment was actually an attempt to fund general fire protection services. Now, Proposition 218 limits government's ability to impose assessments to situations where there is a special benefit conferred on real property, and the assessment must be in proportion to the special benefit actually conferred on any particular parcel. The special assessment for the fire district was clearly intended simply as a general benefit for fire protection services, and it also was not proportional to services actually conferred. So the special assessment appeared to violate the requirements of 218, and the court struck it down. I'll tell you, the reasoning and the result in this case seemed pretty clear to me at the time, so the Supreme Court's grant of review is a surprise. This could turn out to be a very important case in the interpretation of Proposition 218 if the Supreme Court reverses. And that's it for today's Kelso Report. Have a great day in the law and a good weekend.